Good morning, gentlemen. I'm here with Eric Kidinji. We are petitioners in a constitutional petition number E418 of 2022, which unfortunately was struck out by the High Court yesterday. I say unfortunate because we were never given a chance to articulate what had brought us to court. The court moved on its own motion, what I think lawyers call suo motu. The petition was struck out. We do not agree with the reasons given by the judge why she struck out our petition, basically because ours was not an election petition, and it has nothing to do with the ongoing petition at the Supreme Court. Ours was simply a constitutional petition for interpretation of Section 80, subsection 4A of the Elections Act, which, in our opinion, is in direct conflict with Article 138.10 and Article 140, sub-Article 3 of the Constitution. In that, Section 80, subsection 4A, purports to give powers to an election court to declare a winner of a presidential election upon a recount of votes or ballots cast. And if you look at Article 138.10 of the Constitution, that mandate is exclusively a mandate of the chairperson of the IEBC. Number two, Article 140 of the Constitution sets out the consequence of nullification of a presidential election by the Supreme Court. The consequence is the holding of fresh elections within 60 days upon the determination of the Supreme Court. Going back to Section 84A of the Elections Act, that section purports to provide that an election court, of which the Supreme Court is one, just like the High Court and the subordinate court are election courts under the Act, it purports to give powers to an election court to declare a winner of a presidential election pursuant to a recount or retallying of votes. And you are saying this section, being in direct conflict with the clear provisions of the Constitution, is unconstitutional. So when we moved to court as petitioners, our case was that the High Court should give an interpretation of Section 80, subsection 4A, vis-a-vis the provisions of the Constitution to determine whether that section is consistent with the Constitution or it is inconsistent with the Constitution. So we must get this clear that our petition has nothing to do with what is pending in the Supreme Court. The jurisdiction of the High Court in matters of constitutional interpretation is well spelled out in Article 165, sub-article, I believe, sub-article 3, sub-article 3D. It's very clear. I have a copy of my Constitution here, but I don't have to read it out. You can look at that afterwards. But it is clear. It is only the High Court that has exclusive, unlimited, original jurisdiction in matters of constitutional interpretation. The Supreme Court can render an opinion which can be used by the High Court, but it cannot interpret the Constitution and declare a certain statute inconsistent and hence unconstitutional. That preserve is purely for the High Court under that Article 165, Sub-Article 3D. So we are saying we had come to the right forum, which is the High Court. We could not go to the Supreme Court because we are not contesting the election. Ours is to seek interpretation, and that is why we landed in the High Court. So we just picked the certified copy of the Honorable Judge's order, which also constitutes the proceedings of the court. And I'll say proceedings in quotes because actually no proceedings took place because we never appeared in court. We were never given a chance to articulate our petition. And we believe on that basis alone of the fact that we were not given a fair hearing, the rules of natural justice come into play. We were denied a chance to be heard. And if anything, the least the court should have done is ask us to serve the parties, that is the Honorable Attorney General, and the interested parties whom we have named as the IBC and the Honorable William Samoei Ruto, who is the president-elect. And note, we've named these parties as interested parties, not as respondents. We are not suing them. We're only suing the Attorney General, because the Attorney General is the originator of our statutory laws. So in that event, it is only the Attorney General who could raise that issue of jurisdiction by way of a preliminary objection. But that would not have come upon service of our documents upon the Attorney General. We are not given that chance to serve our documents, let the AG come to court, and raise their objections. So basically, we are moving to the Court of Appeal because procedure does not allow us to go to the Supreme Court without first going to the Court of Appeal. The Supreme Court, I believe under Article 163, I think 3 or 4, Sub-Article 3 or 4, can make interpretation of the Constitution, but based on an appeal from the Court of Appeal. You cannot go directly to the Supreme Court to seek interpretation of a statute. No, that you cannot do. You can only access the Supreme Court via an appeal from the Court of Appeal. So in short, we are saying that because this is a matter of immense public interest and importance, we have a duty as citizens to ensure that justice is done to all the parties concerned. And for posterity, we are not just looking at the pending presidential election petition. We are looking at posterity. We are saying that let the High Court come clean and give us an interpretation of this Section 80, subsection 4A of the Elections Act. And mind you, we are not contesting that that entire section is unconstitutional. No. We are saying it is unconstitutional to the extent that it purports to give powers to the Supreme Court to declare a losing petitioner, presidential candidate, as president-elect upon a recount of votes. We are not saying that the entire section is unconstitutional. No. If you look at our petition, which is, I think I have a copy here, and I believe even you gentlemen and ladies, you have your copies, it is clearly headed Constitutional Petition. It is not election petition. It's not any other kind of petition. And it goes ahead and says, in the matter of a constitutional petition to declare Section 84A of the Elections Act, blah, 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 unconstitutional, null, and void. So we are just seeking interpretation. We are not contesting anyone's election or supporting anyone's election. We are just seeking interpretation of that section. And it is in that vein that being dissatisfied with the order of the High Court striking out our petition, we intend to move to the Court of Appeal as soon as tomorrow. Now that we have a certified copy of that order and what seemingly constitutes the proceedings, we shall prepare our papers, instruct lawyers afresh, and move on to the Court of Appeal. One last thing is, one of the tenets of justice, you cannot shut out a litigant who has expended on court filing fees, which do not come cheap, who has expended on lawyers' fees, who has spent time to prepare and file documents in court. You must hear that litigant. And that is the audience we are seeking as petitioners. And I think with those few remarks, we can meet at the Court of Appeal when we file our appeal papers. Once again, let me stress that there being no appeal on record as yet, and the petition having been struck out, whatever we are saying here is not sub judice. We are not commenting on any matter pending before court. It has already been dispensed with, so to speak. So I think unless there's anyone who wants any clarification, we are good to go.